A battle worth fighting for. Why the Equal Rights Amendment really isn't dead, and President Joe Biden could add it to the Constitution with the stroke of a pen. Welcome to the No Spin Zone. Graph's Grievances starts right now. With just over 30 days left in his administration, President Joe Biden is being urged by scores of Democratic lawmakers across the nation to add the Equal Rights Amendment to the U.S. Constitution. First proposed 101 years ago, the Equal Rights Amendment would explicitly guarantee sexual equality in the United States. And despite the difficult and time-consuming process for adding an amendment to the Constitution, the Equal Rights Amendment appears to have met those high qualifications. As outlined in Article 5 of the Constitution, one way to amend the document is for 2/3 of both the House and Senate to vote to approve a proposed amendment, and then for that amendment to be ratified by 3/4 of the state legislatures. In 1972, both the House and Senate approved the Equal Rights Amendment, and over the course of the next 48 years, 3/4 of the state legislators ratified the amendment, with Virginia becoming the 38th and final state to do so on January 27, 2020. So why has the Equal Rights Amendment, also known as the ERA, not been added to the Constitution as the 28th Amendment? As far as I can tell, largely because of cowardliness on the part of Democrats. After Virginia ratified the ERA almost 5 years ago, the National Archivist, who is responsible for the certification and publication of constitutional amendments, declined to add the ERA to the Constitution. The archivist, citing a memo issued by Donald Trump's Justice Department, which argued the ERA had, quote, expired, and hence did not meet a 1982 deadline for ratification. And I am sure you're now thinking, deadline? What deadline? Well, while the Constitution makes no mention of a deadline for ratification of a proposed amendment, the House and the Senate inserted a 7-year deadline when they approved the ERA back in 1972. Meaning the amendment would have to be approved by 3/4 of the state legislators by 1979. This, of course, did not happen. It took an additional 41 years for the 3/4 requirement to be met in 2020. And by then, some states had even rescinded their ratifications. Despite this, many Democrats and legal scholars argue that the deadline for ratification of an amendment is irrelevant and unconstitutional. Remember, the Constitution, which explicitly lays out how to amend it, makes no mention of any deadlines. If the founders wanted a deadline to amend the Constitution, they easily could have stated as such. But they did not. In fact, they seem to have done everything possible to make sure it took a very long time in order to preserve the document. The Constitution lays out the role of Congress, and notably does not give the legislative branch the power to impose a time limit for ratification of a proposed amendment. And as for some states trying to rescind their ratification of the ERA, the Constitution does not give any state legislators that power either. Yet despite all of this, Trump's Justice Department said no to the ERA, and Democrats, until now, have largely just accepted that decision. But thanks to Senator Kirsten Gillibrand, the issue of resurrecting the ERA is now front and center. The Democrat from New York is publicly and privately pressuring President Joe Biden to direct the National Archivist to publish the ERA as the 28th Amendment. Gillibrand arguing that President Biden should not have to abide by the Trump Justice Department's deeply flawed legal reasoning. And once the ERA is published, it will be presumed valid, and the burden of proof will be on the opponents of equality to prove otherwise. The senator is absolutely correct and embodies the fight that Democrats must be willing to wage in the era of Donald Trump. The president-elect is not only lawless, but concocts policy out of thin air. Democrats need to use every legal remedy they have to fight back against him. Senator Gillibrand is not only doing that, but cunningly using a Republican-embraced legal theory, constitutional conservatism, to achieve sex equality. Gillibrand is saying, adhere to the text of the Constitution. Don't allow a ridiculous Trump legal opinion to stop progress. And yes, lawsuits will come, but defending the equality of women is the fight Democrats should want to wage. Exposing Republicans as being against that basic principle, especially as states across the country deny women the right to abortion. Adding the ERA to the Constitution would be a historic and wonderful coda to the monumental presidency of President Joe Biden. I hope he takes action. Thank you for watching Graf's Grievances. Let me know what you think. Please like, subscribe, share, and join me tomorrow for more.